So that's the approach of the government. The approach from a human rights perspective will be to say, well, look, maybe economic stability and the way you treat the dignity with which you treat individuals are very much intertwined. And whether or not that succeeds remains to be seen. On your second question about Asian values, that came out very strongly in the High Court judgment on the equality challenge, where the Confucian notion of procreation was cited as one of the reasons to retain the gross indecency provisions. Again, completely oblivious to the fact that this comes from Victorian England.
I will try to answer the question. Okay, I'm not, as I mentioned in the presentation, it's very difficult to reach consensus on the content and approach of human rights under the Asian value. But what I can do is basically to discuss on the contents and approaches of human rights in Malaysia. With regard to the contents, okay, to the Malaysian government, the content has to be determined based on the local moral and religious value, and not, alien value to the Malaysian society, not international standard. There's no such thing as universality in human rights. That is the understanding of the Malaysian in determining the contents. When they interpret the human right provision, they tend to look at the value and the local moral and religious value. And in fact, when we talk about this content, the issue of LGBT, probably I can share with you all, that is a very hot topic in Malaysia, LGBT, where the NGOs has applied to organize a campaign to promote LGBT. They call it sexuality independence. Yeah, they request for permit to organize a campaign, a demonstration, but was rejected. And the activists took the matter to the High Court for judicial reviews, and it was decided by court that campaign in Malaysia will be a threat to national security and public order. So that's how they arrived to the determination of the scope, of the content of human rights. And with regard to the approach, as I mentioned in my presentation, approach in human rights, according to a Malaysian perspective, is very much different than the international human rights approach, whereby it focuses more on the economic, social, and cultural rights, to the extent that civil and political rights become luxuries in Malaysia. So basically, Malaysia has to maintain political stability and has to maintain economic development before everybody can enjoy civil and political rights. So that is the first features, the first approach. The second one will be the priority given to the community right rather than individual rights. So this is also the basis or justification for Malaysia to keep holding to the life to death sentencing in Malaysia. Not to say that Malaysia human rights advocate has not done their good job to promote for abolishment of the death penalty, but to the Malaysian state, the Malaysian government, the rights of the community, the peace and harmony, the political stability, the security is more important of the community or of the state at large, is more important than the right to life of an individual drug trafficker or murderer. So this is the problem. Even for when Remy mentioned about the first in his presentation that back in November. You know, Malaysia, for everybody's knowledge, we used to have that before 1980s. You know, before 1980 something. I'm stand to be corrected in terms of the year. We used to have similar provision in Malaysia where for offences under Dangerous Drug Act, for drug trafficking, upon conviction, the judge has a discretionary powers to sentence the convict to life imprisonment and not death penalty. We used to have that, but the DDA, Dangerous Drug Act, has been amended because the state, especially adopted by the parliament, you know, was of the view that, you know, by allowing one, you know, drug trafficker to survive the death sentence is not actually doing justice to, you know, to the community in Malaysia.
Thank you. Okay. Yeah. Okay. Let me get an overview. 1, 2, 3, 4.
Thank you very much. I see so many people eager to discuss that we should be rather short. First of all, I would like to thank you very much for your very informative and interesting. I learned a lot. Just one small comment. You mentioned that in place of Dr. Nordin, 40 years ago, we had another doctor from Poland, and she would be saying absolutely the same. So I didn't know that at that time we defended Asian values. That's what they did. Economic social rights, community rights, that was social. That was the sort of Asian values in Poland defended 40 years ago. But fortunately, 20 years ago, we abandoned that path. My question would be, you are saying that the government is insisting on economic and social rights. Is Malaysia a part of the International Covenant on Economic and Social Rights? So if there is a so strong emphasis on this particular right, why not to join this particular covenant and accept the individual complaints as a protocol? Are there any thoughts, are there any idea about that? That was my first question. And my question to both of you would be, are there any discussion about creating some kind of regional system of protection in Southeast Asia, for example, something which will give priority to Asian values? And then there's one small question because I was pleased to learn that UPR, with all its limits, had some effect in Malaysia. You can say the same in Singapore, that also the UPR is, in a way, having an impact on the situation of human rights in your country. Thank you.
May I collect the first 3 questions first? Yeah. Or would you like to?
Yeah, better to collect, because they will be the same.
Sam, please.
I'd like to preface my question with, first of all, thanks for 2 interesting, but unfortunately very depressing presentations about the state of rights. And secondly, an expression of depression and exasperation at the renewal or the never-ending sterility of this debate between universality and Asian values. I find it immensely difficult, you know, to take the self-serving, cynical proposals that Lee Kuan Yew and Mahathir Mohamad have made tremendously seriously, but they have a huge impact. What we are witnessing here is an ongoing confrontation between 2 absolutisms: universality on the one hand and communitarian values on the one hand, and they are equally damaging. It's no use, I think, for us to be talking about making very good objections to what we might call market fundamentalism, the Washington Consensus, only to replace it with different kinds of fundamentalisms, because everybody loses from the fundamentalisms. So, you know, this brings to mind the Chinese proverb, be careful what you wish for because it may come true. Well, for most of my adult life, I've been wishing for an end to American hegemony, only to find maybe that as the world shifts on its axis from west to east, a different kind of hegemony might emerge. And my question to both of you is whether what is happening in Malaysia and Singapore and elsewhere in Asia is the reflection of what is now being termed a Beijing consensus, although I don't know how you can have a consensus of one, but anyway. The idea that there is a trade-off, that we will improve your standard of living, we will provide security as long as you shut up and behave. Don't ask for civil and political rights, because that's not part of the deal. And already we can see this influencing authoritarian regimes in Africa and elsewhere. And is this a danger that you foresee?
Thank you. Professor Ratna.
Yes, thanks very much. Is it on?
Question, would you quickly help? Okay. Madam, this one, please.
Hello. Yes, thank you very much. I enjoyed both those presentations very, very much indeed. And I guess I'm going to try and take a slightly different take on this. It's just that what I really enjoyed, I actually see what you both said as Asian cultural values on the wane. Nobody actually takes it seriously anymore. I mean, you know, that little tiny reference to 377 being a Confucius value. I think the sort of new sides of resistance and advocacy seems to be prompted by globalization and a new economic order, a new neoliberal economic order in Malaysia as well as in Singapore, it seems to me. Because what I heard was that these sites are coming from, and should have been anticipated but weren't, were coming from online advocacy, for example, and the internet. For migrants, which are integral, and that's been an issue certainly in Malaysia for rather a long period of time, but are integral for the engine of neoliberalism to actually work. And to start, they can maybe repatriate a handful from Singapore. It doesn't seem to me that could be a long-term solution at all, at least not to the extent that it might even, damage Singapore's aspirations to become the Geneva of the East, right, in some ways. And the third area would be just pink cells. It seems to me that there's a sort of a new kind of pink advocacy, that whether it's through online or through these pink dot campaigns, which in themselves produce all sorts of markets. Whether they're sort of souvenirs or just the fact that they invite tourism. And that is what's partly pushing the agenda to the surface and forcing governments to confront these. It doesn't seem to me in either context, and I maybe heard it different from Sammy, that there's even more deeply entrenched hardline stances. It seems to me the governments are actually budging. Maybe not in the direction you want them to budge, but it certainly doesn't seem to me that there's even more repression or more brutalization. Partly because that would damage their own, new economic projects. I'd like a response from both of you on that.
May I ask for a first round of response, please?
First off, I'm not a theorist. I'm a practitioner. And as a practitioner in the Singapore courts, you do not have, there's very little sense of these great global debates. It is difficult enough as a practitioner interested in human rights in Singapore to educate or to discuss constitutionalism, let alone international human rights theories. But what you said about an emerging Beijing consensus, or what appears to be an emerging Beijing consensus, I think unfortunately finds some significant inspiration in Singapore. I know for a fact that the Communist Party in China sends local officials to study, to observe and to study grassroots democracy at the municipal level in Singapore, to learn how officials in Singapore respond very actively to residents, to take care of residents' needs, without having to enter into uncomfortable debates or discussions about rights. The way the ruling party is structured in Singapore is a Leninist model, where you have a central executive committee and cadres Central Executive Committee chooses cardis vote for your Politburo, your core group. Regrettably, a lot of the Singapore model has been exported and has been used as inspiration. Where I think that there is some hope is here, that Singapore has achieved great economic growth, and we are at a crossroads, a political crossroads. So I don't think the answer to the never-ending cycle of universality versus Asian values is going to have an ideological answer. I think, at least in Singapore, the answer might be political. It might be an increasing pluralization driven by, as Ratna pointed out, social media, and increasing diffusion of information control, increasing advocacy on equality, on LGBT rights. To answer your question too, yes, there is a budget. There is a budget, and in the last decade especially, you see a marked lack of enthusiasm on the part of the Singapore government for enforcing something like 3778. But I mean, that is dangerous, and that is problematic in its own right, because at the end of the day, it still gives the courts cover to say, if it's not being enforced, let's just keep it there. On the UPR process, unfortunately, the UPR process is very much might as well not have happened in Singapore. You could ask 1,000 Singaporeans. I would be shocked if one says they know what the process is about. But that was our first stab at it, and increasingly, I think you are seeing more organized groups in civil society saying, we want to make a representation at the UPR, we want to challenge the state's positions, we want to question some of its statements. And one very interesting challenge came in the Singapore government's report to the CDAW committee, where the government made the concession that equality under our constitution covers sexual equality, even though it's not spelled out. It was an attempt to fudge the issue, but we use this in court in challenging 3778 to say that, look, you have made a concession in an international forum that equality under our constitution does cover sexual orientation as well as gender. Unfortunately, it wasn't effective.
Right, Abhi.
Okay. Thank you for all those questions. With regard to the first question, whether Malaysia is the party to ICSCR, the answer is no. And why not? Why not Malaysia become party to the treaties? I've been trying to, figure out the reason. Because the problem with Malaysia is that Malaysia stand is that they will only sign international treaty when domestic infrastructure, legal infrastructure, allow them to fulfill all the obligation under that treaties. So until now, somehow Malaysian law or the legal infrastructure will not allow Malaysia to fulfill the obligation under ICCPR and ICSCR until and unless they repeal the provision that allow, for example, death penalty in Malaysia, they won't sign ICCPR. So that is their stance. Okay, they being asked, why Malaysia has not signed ICCPR so since 1966, and they've been saying, oh, we're considering. So after so many years, almost 20 years, 30 years, they're still considering of signing ICCPR and ICCR. And let me share you one story with regard to the Rome Statute. Malaysia still not party to the Rome Statute, but in 2011, Malaysian official has in an an international meeting on Rome Statute make an undertaking that Malaysia will sign very soon. That was in 2011. And that same undertaking was repeated in 2012. And guess what? Because of that undertaking, Philippines has signed Rome Statute. But until now, Malaysia has not signed it. So it was funny when the other day when I attended a conference, I was told by this Philippine counterpart that Malaysian undertaking to sign has actually influenced Philippines to sign Rome Statute. So, and until now, Malaysia is still considering and signing Rome Statute. And apparently, I do not know, I heard that every state member of the ASEAN is actually looking forward, because like Singapore and Brunei, they already said officially that they will sign after Malaysia signs. Alright, so that is the situation. That is the reason why Malaysia has not signed ICCPR, ICICR. Yes, they give priority to economic and social rights, but they're not willing to actually, make it official, make it as a legal obligation under the international law. And with regard to Prof. Kapur's remark on this solution, yes, I do admit this is not a long-term solution, but to me, any solution is a good solution when we talk about human rights, okay? Even though it is merely for a short period, okay, but it's still a solution, I've been telling, when I started teaching human rights in University Kebangsaan Malaysia, I was surprised when all my master students, majority 90% were saying, there's no such thing as human rights protection in Malaysia. So there's no actually, hope that there's no guarantee that we can use the knowledge that we gain in this classroom to actually make a change in Malaysia. I said, no, that is not the situation. So if you're not happy with the current position in Malaysia, so you have to take my class, and then you learn about it, and then you are the one who's supposed to work to make changes in Malaysia, and every single change counts, to my view. And UPR, what Remy was saying, not really effective approach, especially when we talk about enforcement of international human rights law. So we discuss about this UPR mechanism, and when we discuss about treaty-based mechanism, yes, there's no legal stance, but somehow it gives the moral and political pressure on Malaysia. When it received 103 recommendations in 2009, the premiership, the government has done something, and what we have is the repeal of the draconian law, and the right has been given back to the people, but of course with limitation, and there's no absolute human right. There's no such thing as absolute human rights in Malaysia. Thank you.
Yes, then Mr. Navi, and it was Hitoshi, yeah? Okay, Mr. Navi first and then Hitoshi.
Coordinators of the Asia Pacific Human Rights Facilitating Team in the run-up to the World Conference on Human Rights. And the governmental report emanating from Bangkok was dead on arrival because of the excellent report done by the NGOs. In fact, both South Korea and Indonesia distanced themselves from the governmental report informally. This was reflected in the much subsequent later on discussions when Malaysia, in the ASEAN Declaration on Human Rights, tried to extol the primacy of community rights against individual rights, and they did not find a place in the final declaration. So the Malaysian attempt to do community rights failed. Now let me quickly come to two factual problems I had with the presentation from Malaysia. The UPR in its second session has just ended on Malaysia last week in Geneva, and we are waiting for the concluding observations to come out. The point was made that the Internal Security Act has been repealed. This was said in the August 2013 report, but the good Malaysian government, by a brilliant sleight of hand, in October 3rd, 2013, moved and passed the Prevention of Crime Act, which authorizes the government to detain certain criminal suspects without trial for renewable terms of 2 years. So it's a nice, good little revolving door legislative framework that the Malaysian government has evolved. Second factual, and I'll end here because for reasons of time brevity, I have a shopping list which I shall not go into, which is religious freedom. Malaysia states in its August 2013 report that it now has the Peaceful Assembly Act of 2012. Thank you very much. However, the Department of Islamic Development Malaysia, JAKIM, within the Prime Minister's office, says that any such deviant behavior by certain religious sects, importantly, such an important sect like the Shia, which is not a sect, the Ahmadiyya, and the others like Al-Arqam, all their meetings will be banned. So much for freedom of assembly. Thank you very much.
Thank you, please.
My question is also to Dr. Nardin. It's a question I think concerns the difference between rhetoric and reality. Yes, you could say that the Asian values sort of emerged as a rhetoric against universal values of human rights, but whether that really impact the reality of what the government is actually doing is another question. And from what I understand from your presentation, I think basically you are saying that in reality, Asian value is not really challenging universality. Rather, it's actually universal human rights instrument is actually accommodating Asian values. You said that there is a scope in which those Asian values can be implemented or can be expressed through the implementation of various obligations under the human rights instruments. And certainly I'm a former member of the Human Rights Committee, Nisuke Ando, the Japanese member, expresses the view that the RCDPR is flexible enough to accommodate different cultural or religious values in its own instruments and often expressed through individual opinion expressed by certain members of the committee. It seems to me that what you're saying that yes, there is a Asian values debate and it's been used as a rhetoric, but in reality the universal instrument, those international instruments, is actually universal in the sense that instrument itself accommodates the different values and ideas through the implementation of obligations. In relation to the Universal Declaration of Human Rights, if I'm not mistaken, I think Malaysia was one of the few Asian countries which participated in the drafting of Universal Declaration of Human Rights. So you can't really say that it's a Western product. There was an Asian contribution to the drafting of UDHR. It's from what I understand from your presentation, there is rhetoric against universalism against Asian values, but what you have been arguing seems to be actually reinforcing the view that international human rights is actually a universal instrument which accommodate Asian values.
Thank you. Response, please.
Ravi, I agree to the point that you have cited, shared with us, and I don't have intention to reply or to rebut on that. I don't have any intention because I'll be trapped in the process Okay, thank you for that comment. And with regard to the second question on the Asian value, whether this is actually being implemented in reality, in practice, I have to agree that this Asian value, which is also related to what they call relativism, relativity in human rights, has been, in reality, has been adopted selectively. I have to concede that, yeah. And me personally, as an educator, I have issues. I have reservation in adopting relativity in human rights, because first of all, when for example, when the state cite that human rights scope and approach to be determined based on the religion, for example, religion of Islam, who will determine that? Is it going to be the state, or is it going to be the religious council? So there's issue of uncertainty in determining this scope. For example, like right to education for women in Malaysia is okay, is fine, but is within the teaching of Islam, but not probably in Afghanistan and Taliban, where the woman doesn't have the similar right, but they claim that is part of the teaching of Islam. So which definition, which approach that we have to adopt in determining that? There's uncertainty. And also, my second concern on this relativity in human rights is it tends to be used to support the violation of human rights itself by the state. Yeah, so yes, but of course, when I teach, I always give these two positions to my students. We have, universality in human rights, we have relativity in human rights, and it's always my approach when I, teach human rights. And with regard to your question on the UDHR, I stand to be corrected, but UDHR, when it was negotiated and drafted, only around 49 to 50 states were involved in the drafting mechanism, and majority were from Western nation, and not from African, not from Asian. That's okay. I stand to be corrected, and then that's the reason why Malaysia always look at UDHR as a Western instrument. When the process of negotiation, it only involved the idea and the thought of the Westernizer. But let me bring you to Malaysia. The issue of rejection, the judiciary stand, the two cases that I mentioned, Merdeka University and as well as the other case, the judiciary rejected to look at the UDHR not because they contain of the alien standard, but because UDHR is just a soft law. It's declaratory in nature and doesn't bind Malaysia. Thank you.
Okay, thank you very much. We are over time. I would like to thank the presenters, the speakers for their interesting presentations, and the audience for participation and attention. Thank you very much. Please a warm applause.
Thank you, Dr. Rohaya Norton and Mr. Remy, for a very, very brilliant discussion today. And now, ladies and gentlemen, we come to the end of conference today, and we also wish to see you tomorrow. So we have another conference, another program for tomorrow. And yes, so have a nice day. Thank you.